Quite a few more people have joined. So I'll make a start just because it's a start time at the moment and I've got quite a lot that I want to get through with everybody. For those of you that don't know me, I'm Odette Gordon. I'm the landlord and residential tenant specialist here at CWJ. Now, I know a lot of people there's been a lot of issues going on in the past with coronavirus, and there's been a lot of dates thrown out by the courts and the government. It's been, in my opinion, a complete shambles, to be honest. So I recently held a webinar regarding the stay on evictions, which, as everybody hopefully will be aware of now, was lifted on the 20th of September. It didn't come without, I suppose, other boundaries that were put in place, unfortunately. And that's the sort of stuff that I want to talk about today, mainly what the new restrictions are on serving notices, the new rules when you're issuing possession claims, updates on if you've got current possession claims that are ongoing in the court. Feel free at any point to ask me a question or type something in the chat. I'm more than happy to answer questions at any point. If it's relevant to maybe a subtopic that I'm going to get onto, then I may say that I'll deal with that sort of a later date. But at the moment, what I want to talk about first of all is the Section 21 notices and the Section 8 notices that you would generally serve on your tenants for any reason, rent arrears, or if you just want your property back. There are, the rumours are true, unfortunately, that you do have to give your tenants 6 months notice from anything that's served from the 29th of August. And the unfortunate thing about that is they haven't, it's a bit open-ended. The government are saying, and the new rules is at least until the 31st of March 2021. That could change, as everything has done at the last minute. So at the moment, it's 6 months notice to all your tenants. Now, there are some, I suppose, with anything, so mainly on a Section 8. So if you've got rent arrears that are 6 months or more, then you are actually entitled to give your tenant 4 weeks notice and commence proceedings against them. There are some other rules regarding antisocial behaviour and nuisance as well, which is you can serve a Section 8 notice and then you can issue court proceedings after a short period of time. We're not going to go quite into those at the moment, and if you do have any queries about those at a later date, then do feel free to drop me an email and we can discuss those. Court proceedings. Now, one thing, actually going back to Section 21s and Section 8s, mainly Section 21s, obviously you have to give, as I said, 6 months notice, but you must make sure that you meet all the legal requirements prior to issuing any notices. So that would be making sure that the deposit was protected properly, making sure that you've provided your tenants with all the prescribed information, i.e. a gas safety certificate, EPC, how to rent booklet. Your EPC also needs to be grade F or above as well. There's lots of requirements that you have to make sure there's all tick boxes to make sure that you are entitled to issue that Section 21. If you're unsure for any reason, some people have agents involved. A lot of the time that we do say, obviously, seek independent legal advice on that. So once again, I'm more than happy to have a look at anything for anyone or answer any queries on that. New possession proceedings. They're not as complicated as they've made out. The issue is that there's almost an extra step in the possession proceedings. So what will happen is you'll issue your claim, you'll get a notice of issue. I mean, at the moment, the courts are taking quite some time, to be honest, to issue claims. It can be anywhere from 4 to 6 weeks just to get a notice of issue. Then a tenant has 14 days from that date to respond. If they don't, then there are two options. You have your accelerated possession procedure or your standard. If it's your accelerated, then you're entitled to request for possession. If it's a standard, what the court will now do is they will provide you with a review appointment and a hearing date. So your review appointment will be first, and then your hearing date will be 28 days after that review appointment. Now, when that review appointment could be, I don't know, but there's going to be lots of queries. They're going to ask you whether you've provided your tenant with information on the Coronavirus Act, whether you've asked them any questions about that. You are required to provide the court with details of any, I suppose, any issues and that your tenant has been affected by due to coronavirus. So that would be whether they're facing financial hardship, pretty much that's it, or whether they've suffered bad health from it, anything like that. You will be required to try and find out and tell the court. There are some other, it's a bit more specialist. There are options if you as a landlord have been affected by the coronavirus situation and you intend to issue court proceedings. You can mark your court proceedings as a COVID-19 case and list as to why it's relevant to the COVID-19, i.e. that, I don't know, you have been financially affected by everything, and maybe you need to sell that property that your tenant's in. They'll deal with it more, they'll deal with it as a priority, but you have to prove that it is a COVID-19 related case. And the judges have been very clear on that in the guidance. So, I mean, another thing is a lot of people have been a bit concerned about ongoing possession cases that they've got going. Now, the main thing is that the court aren't going to contact you. You must contact the court and provide what they call a reactivation form, which is effectively an email, just requesting the court to reactivate your possession claim as to where it was. It will be stayed to the point. So, for instance, if you've got a notice of issue, there won't be anything done on it. And at the point of reactivation, you again will be required to provide the court with any details regarding the tenants being affected by coronavirus. Everything is, there's lots and lots of issues regarding it. They are doing everything they can to effectively keep tenants in properties. My personal opinion is that they're not really thinking about the landlord's side of things. For instance, I know that they've talked about you can make take a holiday payment up to the 31st of October, but it doesn't necessarily mean that a landlord is going to be entitled to that, and that could then end up putting you in financial hardship, which I suppose then puts you into the bracket of it being related to a COVID-19 case. But once again, everything is going to always take time, and they're doing absolutely everything they can to keep tenants in their properties. Another factor of that is a lot of people have been waiting for bailiffs appointments. Now, with the bailiff side of things, they are, I've had bailiff's appointment coming through. There are some slight changes. Normally, a bailiff would have to give 7 days notice to a tenant that they were attending. That's now changed to 14 days. That's now changed to 14 days. There is also a little, it's not huge, but there is a moratorium on evictions between the 11th of December and the 11th of January. So anything over the Christmas period, there will be no evictions on residential properties. That goes further to say, if you have a property that is in a local lockdown area, they will also not be able to undertake any evictions in that area until further notice. So until those restrictions are eased, bailiffs will not be able to undertake any evictions in there. Got a question. It says, my tenant will not allow me to carry out repairs to the property due to the coronavirus. What should I do? During, I suppose, the height of the pandemic, I know there's a second wave issue going on at the moment, but during the height of the pandemic, there were a lot of issues regarding repairs to properties. Now, that has, the government guidelines on that are that repairs can be carried out as long as they are carried out under the, within the government guidelines. So anything that needs to be done should be done. Your tenant should be working with you as well. And if they aren't helping you effectively, they're in breach of their lease. If they are really if they are risk tenants, then there are, I suppose you could work with them. There's lots of things that we could do. Every case is completely individual, so it completely depends on the individual factors. But let's just say it's a normal case and your tenant isn't letting you into the property because they're concerned. The guidelines are that repairs should be able to be carried out within any properties at the moment. I don't see, I'm for one not aware of any restrictions regarding repairs to properties as it stands. Now, I'm pretty much at the end of, I suppose, the topics that I wanted to talk about. I'm aware that I've got quite a few landlords that I know of on here. I mean, I know, if there's anything that anyone's got questions on, I'm more than happy to answer them. Has anyone got any questions? Feel free to just put it in the chat. Gas safety checks. So someone's asked me about gas safety checks. Gas safety checks should absolutely be carried out. There's no problem. I see no reason that these can't be done. Tenants should be working with you to allow you to have your gas fitters or everything to be checked, just as you always would. There's no reason that shouldn't be done, unless they can provide some real reason as to why they are unable to let someone into the property. There's no reason they shouldn't be having the gas safety checks done. And some of you may be aware, some of you may not, as a requirement of being a landlord, you are required to have those done yearly. So, but if for instance, your tenant didn't do that, and that was a reason that they attempted to not let you have possession, as long as you've got the evidence that you have tried to get them to let you into the property, there should be no problem with anything like that. I mean, it's not necessarily that you don't need to necessarily need to notify anyone that there's no gas safety certificate. Obviously, you will be aware. The issue will occur as to when you want to get possession of the property. That's the main concern, is because in possession proceedings, there is a question as to has the tenant been provided with a gas safety certificate. Now, you will be able to answer yes, and then you'll be able to provide the last date of when it was given, and then provide a reason below as to why another one hasn't been done. And it'll be, you can provide all the correspondence to the tenant. So I'd always say to put stuff in writing, maybe email or anything like that, that you have requested access and that they've refused. I have another question regarding tenants leaving properties early. My tenant wants to leave the property early as they cannot afford to pay the rent. Or what should I do? This is really one for landlords to think about. There's nothing really, I mean, on the odd occasion, I suppose you would think about getting legal advice on it. But ultimately, I think you have to think about the pros and the cons. So let's say your tenant wants to leave the property early because they can't afford to pay, which is what this question is about. Would you rather have a tenant in there that's not paying any rent, or have a property that's empty, knowing that you're going, you can have that property ready to get tenants in there, and hopefully that'd be fairly quickly, or go for the rigmarole of, and that's what it would be at the moment, of having someone that's not paying rent, serving a Section 8 notice, having to wait 6 months. Then, tenants, my personal opinion, even professional opinion, would be that if a tenant wants to leave early because they cannot pay their rent, you need to seriously take consideration as to whether you accept that, given the current situation that we are facing with the timelines for getting possession of properties under any circumstances. I had another one regarding, because of has the deadline for electrical safety checks been extended beyond next March? That's something that I would want to come back to you on. It's not really in the substance of this topic right now, but I can, if you email me, then we can discuss that further. It's not a problem on my part. Got no other questions at the moment. Does anybody else have any other questions? Any queries on anything? No? So I'm more than happy to respond separately to the electrical safety query, and I'll do that shortly. But other than that, thank you everybody for joining me. I really appreciate it. And I mean, who knows what the future is going to hold? I'm sure that these will, these updates will be coming thick and fast. So just look out for any other webinars that we're going to do, any other updates. We will try and do them as much as we can, just to assist people. It has been a really, shaky time for quite a lot of people, and definitely not clear in any event when you look at all the dates that they've thrown around. From March to August, saying that this was going to be done the 11th hour of the eviction ban lifting. So it's a lot to take in for everybody. I mean, I know me personally, that's the same. So thank you so much for joining, and just look out for any more updates. Okay, thanks very much.